NACDL is the association of the nation's criminal defense bar.
In America, if you are accused of a crime, you have the constitutional right to all information in the government's possession that is favorable to your case. For example, is there a witness who failed to pick you out of the lineup? Did another person confess to the crime? Have there been problems in the police crime lab that have not been disclosed? Access to that type of information is a key component of your right to due process and a fair trial under the U.S. Constitution. In 1963, the U.S. Supreme Court held in Brady v. Maryland that prosecutors have a constitutional duty to turn over to the accused all favorable information pertaining to the determination of guilt or imposition of sentence. If the role of prosecutors is to ensure that justice is done and not just that convictions are secured, why would the government conceal information favorable to the accused? Why would the government risk sending innocent people to prison? Good questions. Recent Supreme Court cases, including the 2011 decision in Connick v. Thompson, as well as the 2012 decision in Smith v. Kane, serve as two examples of miscarriages of justice at the hands of prosecutors violating their disclosure obligations. And then there's the late U.S. Senator Ted Stevens of Alaska, who was also a victim of prosecutorial misconduct. In his case, the court and its investigators found that 6 federal prosecutors from the Justice Department's Public Integrity Section themselves committed serious misconduct. Indeed, the court-appointed investigators found that the investigations and prosecutions of Stevens and others in the case were, and I quote, permeated by the systematic concealment of significant evidence that would have independently corroborated his defense and his testimony, and seriously damaged the testimony and credibility of the government's key witness. Tragically, Senator Stevens died before his name could be cleared. In Texas, Michael Morton served nearly 25 years in prison after being wrongfully convicted for the murder of his wife. He was also a victim of prosecutorial misconduct. According to a report recently filed by his attorneys, in addition to failing to meet his independent duty to disclose information that supported Mr. Morton's claim of innocence, the prosecutor also violated a direct court order to that effect. Instead, the prosecutor concealed it for decades. Mr. Morton's prosecutor is now a state judge in Texas. If this can happen to a powerful U.S. senator or a grieving widower, it can happen to you. But what can be done to try to prevent this from happening again?
I am Lisa Wayne, President of the National Association of Criminal Defense Lawyers. Our mission is to foster the expertise of the criminal defense profession and to ensure that everyone facing government prosecution receives fairness and due process. NACDL is a leading voice for criminal justice reform nationally and at the state level, whose input is frequently sought by lawmakers from across the political spectrum. In recent years, there have been many proposals to bring clarity and reliability to the federal rules governing the prosecutor's obligation to disclose evidence to the defendant. Faced with opposition from the Department of Justice, these reform efforts have gone nowhere. The Department of Justice claims that the U.S. Attorney's Manual adequately addresses the federal prosecutor's duty to disclose evidence. But recent cases establish that we cannot accept this reassurance or the tragic consequences of the Department of Justice refusal to follow and enforce its own guidelines. As a result, NACDL established a Discovery Reform Task Force. That task force prepared model legislation which was unanimously adopted by NACDL's Board of Directors.
NACDL's proposed legislation, entitled Duty to Disclose Favorable Information, would establish safeguards to ensure prosecutors meet their disclosure obligations. For example, the reforms set forth in our proposed legislation address the nature of disclosures. Though inspired by Brady v. Maryland and the precedent on which that decision relied, it is the intent of this proposed legislation to eclipse the disagreements and confusion found in post-Brady decisions. It would make clear that the duty applies to any favorable information which is relevant to any stage of the proceeding, from a bail hearing to a motion to keep out illegally obtained evidence, and from the determination of guilt to the matter of sentencing. The timing of disclosures. The proposed legislation directs that prosecutors shall disclose the information, data, documents, evidence, or objects described without delay after arraignment and prior to the entry of any guilty plea pursuant to an agreement with the government, or, if such information is not then known, immediately upon its existence becoming known, without regard to whether the defendant is proceeding to trial or has entered or agreed to enter a guilty plea. The remedies for breach of a prosecutor's duties. For example, the court could postpone a proceeding or limit or exclude testimony. In extreme cases, the court would have the power to dismiss the case or order a new trial. In determining an appropriate sanction, the court would have to consider the totality of the circumstances, including the seriousness of the violation, its impact on the proceedings, and whether the failure resulted from innocent error, negligence, or intentional withholding. It would also allow defendants and public defender offices to recoup reasonable attorney's fees for costs and expenses incurred as a result of the prosecution's failures to meet its discovery obligations.
A prosecution in which information favorable to an accused person is not turned over does not comport with standards of justice. It simply isn't fair. Nearly 50 years ago, the United States Supreme Court was clear in the Brady decision. Society wins not only when the guilty are convicted, but when criminal trials are fair. Justice suffers when any accused person is treated unfairly. NACDL's proposed legislation would fix the problem we have with prosecutors not turning over favorable evidence. The legislation would create clear and meaningful discovery standards governing the prosecution's duty to provide favorable evidence in a timely fashion. A free people should expect nothing less from their government. It's time to put teeth into the prosecution's disclosure requirements under Brady. It's time to stop treating criminal prosecutions like a win-at-all-cost game. Fortunately, members of Congress have been listening, and leading lawmakers have now introduced the Fairness in Disclosure of Evidence Act of 2012. This legislation embodies the key principles that NACDL has been seeking in order to solve this problem with the failure to turn over favorable evidence. We are the National Association of Criminal Defense Lawyers. We are a formidable force in law and policy. But more importantly, we are champions of justice, and we are champions of our Constitution, and we are determined to fix this problem.
To learn more about the need for discovery reform and to access the full text of NACDL's proposed duty to disclose favorable information, legislation, and commentary, please visit www.nacdl.org/discovery reform.